In your book, there's many extracts from judgments of key cases, and last night you were giving some examples of the sort of interventions that you appreciate as a member of the South African Constitutional Court, from the Child Law Centre and the AIDS case from the active NGO as an amici curiae. Again, not looking for advice to NHRIs in another country how to do their business, but speaking from your own experience, what is appreciated, what is helpful to the court in terms of exercising proportionality on fundamental human rights? And it'd be interesting to hear your experience of what works best and what doesn't that help.
Well, if this gives me a chance to say something about the role of civil society and NGOs, even if it doesn't, I'm going to take advantage of it. If one's particularly concerned about groups that are, by their very nature, vulnerable, disempowered, marginalized, and you feel that fundamental rights are of special importance for groups like that, groups that are not listened to, and groups that are often denounced. If they speak, it's often a trap. Then you see the significance of having committed, dedicated civil society groups. I remember being in this country when Ken Loach made a film about the homeless, and shelter was established. And it played a huge role in just focusing attention for groups who didn't have great political clout. None of the parties were really dependent on the homeless. Certainly in South Africa we have strong groups that deal with the rights of the homeless. We have millions of homeless people in the country. We have huge social programs dealing with them. Our court is very embroiled in the constitutionality of these programs, because they often involve evictions in order to, you have to be called clear a slum. Do you call it a slum? These are people's homes. What happens to them in the meanwhile? Is it simply to make way for developers? Were they given a hearing? Is it just and equitable? And we spend a lot of time on cases like that. But we are judges. I don't know anything about homes, building homes, and electricity and water and sewage and best utilization of land and words like reticulation. So we're very dependent on people who do know about those things. You get quite a complex relationship sometimes with desperately poor people, and then idealists like myself implant themselves amongst the poor and speak in the name of the poor with an indignation, sometimes in a ferocity that's greater than the poor actually have, because the poor are often very pragmatic and have to balance out and weigh up all the different interests and see the importance of planning for the long term. But sometimes people who speak in their name see the world in very simplistic terms, and there's the rich are getting richer and the poor are getting poorer. The dynamics are complicated, but the fact is there is dialogue, there is debate, there is material, there is information that's placed before us, and information without which we could barely function. When I think of our jurisprudence, the Gay and Lesbian Equality Project has been extremely important. Our Bill of Rights includes sexual orientation as one of the forbidden grounds of unfair discrimination. And we moved from striking down the penalization of sodomy, ultimately to saying that same-sex couples have the same right to be married under the marriage laws in terms of the common law as heterosexual couples. About 5 different cases, very well prepared documentation, well argued, and you need a good debate with all the different aspects being mentioned. And the same-sex marriages case, we had the Christian Alliance was there, and Mr. Smythe from England, representing very strong religious views was there, and we welcomed the participation in the debate in the court. We've had a number of cases dealing with the rights of the homeless, and bodies like the Legal Resources Centre, which was set up under apartheid to find whatever space there was to use the law to advance human dignity and the rights of people. It not only did that, it trained a whole generation of lawyers, many of whom are judges, some on our court today. It's just a different way of looking at the law. And that empathy is built in. You don't have to struggle. You don't have to do like Pilates exercises to get empathy. It's there from your experience and your vision of law and the role of the lawyers. The Women's Law Centre has brought a number of test cases dealing with questions of patriarchy, violence against women, the women opposed to sexual violence, there are various groups of that kind, also presenting very strong material that feeds into the judicial debate. We've had, or the other areas, there are 5 or 6 areas in which NGOs and civil society will Biowatch. I've just written a judgment for the court on costs awards that were made against Biowatch, wanting to get information about genetically modified organisms that would have had the result of bankrupting Biowatch, even though they were largely successful. We overturned the decision and stressed the importance of the role of bodies like that. We have a Human Rights Commission in South Africa that we from time to time call upon to intervene and to give their views on certain matters. The court doesn't always accept. We had a case dealing with the criminalization of prostitution. The court divided and ultimately upheld the law. We all accepted that the privacy interest at stake, because of the nature of sex work, it's in public, it's indiscriminate. There was some privacy aspect to it, but it was very much undermined by the very nature of the activity, and that Parliament did have a discretion whether or not to criminalise it, but the judgment that Kato Ricken and I wrote set out the arguments for decriminalisation, but saying that's for Parliament to decide, not for the court. But we held that there was a gender dimension, only men were prosecuted and not women, and to the dismay of the sex workers prostitutes, Parliament then introduced a law to make sure that both men and women would be prosecuted in the same way.